Welcome to Aspen Leading Edges podcast. I'm Patty Roberts from St. Mary's University School of Law. Today's guest is Bradley Wendel. He is the Edwin H. Woodruff Professor of Law at Cornell Law School, and he joined the Cornell faculty in 2004. Welcome, Professor Wendel.
Thank you, Dean Roberts, very much. It's good to be here.
Well, I'm delighted to be here at a moment of significance in your scholarly pursuits because you shared with me that just last week, Oxford University Press published your book, Canceling Lawyers. I'd love to start with that because it's such a very pertinent topic, at least from the title. Tell us a little bit about what one could expect from the book, Canceling Lawyers.
Well, it was really fun to work on, and thanks to Aspen, who's also my publisher, for allowing me to promote another publisher's book. But so ever since I've been in this scholarly community, in the legal ethics community, which is primarily what I work in, one of the big debates has been, can lawyers be criticized for the clients they represent? And, you'd think the answer would be no, of course, right? That lawyers aren't identified with their clients and they have distance from their clients and everyone knows that. But there's this long tradition of criticizing lawyers for the clients they represent. And there are these famous little episodes and debates. And, when I started doing this, I met the late Monroe Friedman, a great legal scholar, and there's a thing called the Friedman-Tiger debate where they debate back and forth about whether it's fair for law students to criticize, I think it was Covington and Burling at the time, for representing General Motors, and it was an environmental case, and Friedman and Tiger went round and round about this, and then Tiger later represented someone who had been accused of being a concentration camp guard. John Demjanjuk was his name. And so there's this wonderful debate, and this sort of keeps popping up. There are episodes where we have these big debates about lawyers representing nasty clients, and there was during I think it was the Bush administration, former Obama Justice Department officials had gone to represent detainees in Guantanamo, and conservative commentators called them the Al-Qaeda 7 and tried to smear them in that way. And this keeps going round and round and round. And I wrote a paper about public criticism of lawyers who had worked on the Trump challenges to the 2020 presidential election. And I published a little paper called Lawyer Shaming. And I just have that kind of weird academic personality, which is when there's a debate that goes round and round and never seems to resolve, I think there's got to be something going on here. There's got to be something interesting about this. And so I just dug into it and realized that actually my training as a moral philosopher was helpful. And so I tried to bring some tools from academic moral philosophy to bear, but in a way that would be accessible to non-lawyers and non-philosophers. That was the big challenge in the book, is trying to do both a theoretically interesting thing and account for the kind of never-ending quality of this debate round and round and round. So, we'll see if I pulled it off. It was fun to work on. I spent the last 2 years of my life immersed in this. So it just has now seen the light of day.
And I know that you're co-chair of the MPRE drafting committee, and that you've authored the 7th edition of Examples and Explanations for Professional Responsibility, which is with Aspen. You also have the rules supplement at your desk that you author, the Law Governing Lawyers, Model Rules Restatement, and Other Sources of Law with Aspen. And so you bring a unique perspective to this question of lawyer shaming. I imagine I have an idea where you come out, but besides just pointing to the specific rules, what's the argument that you make that those who are shaming lawyers or canceling lawyers are misinformed and it's ill-advised to do that?
Well, it's the opposite of what I say. I actually don't think they are misinformed.
Oh, my goodness. Well, this is going to be really interesting then.
Cool. Yeah, that would have been the kind of standard book to write, but that's not what I ended up saying. But I am a law of lawyering specialist, and but in a way, the rules don't say much. They're really not very helpful. Basically, they give, with a couple of small exceptions, almost unlimited discretion to lawyers to refuse to represent clients for any reason at all, really. The major thesis of the book is that what accounts for the round and round, never-ending structure of this is there are different registers of moral analysis that are going on simultaneously. So I'm really influenced by a book in 2008 by Tim Scanlon called Moral Dimensions, where he talks about looking at permissibility and blameworthiness as separate, which seems kind of strange, right? It seems like if you're permitted to do something, then it would be incoherent to blame someone for doing that. But Scanlon thinks that the blame actually has something to do with attitudes, and attitudes have something to do with the relational quality of morality. And one of the things that others can do is look at someone and assess their attitudes and what they would be like to be in relationships with as an individual or as members of the community. So I'll give an example from the book. So I have all these case studies of criticisms of lawyers. And one case study is a faculty member at Harvard Law School, Ron Sullivan, criminal defense lawyer and civil rights lawyer, very renowned lawyer, took on the representation of Harvey Weinstein in his criminal trial. And the students at Harvard said, "What are you doing?" And he responded by the kind of standard legal defense. Everyone deserves counsel, Sixth Amendment, protecting the dignity of the accused, yada, 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 yada. And the students kept saying, yeah, we know all that. We're law students, we get it. But we want to know why you are doing this. What is it about Harvey Weinstein's case that attracts you? So this just locks right into the Scanlon analysis. There's something going on there where the students are directing blame at Sullivan for representing Weinstein. And they're saying, we want to know what is it about this case and how does that bear on your attitudes and how you are in relationships, and we may adjust our relationships with you in response, which is another Scanlon thing. We may decide that we don't want you to be in an advising and counseling role with us. We don't want you to be a residential advisor at Harvard University because what you're doing shows something about your attitudes. That's separate from the permissibility of doing this, and it is permissible both legally and morally. And I think what's happening, one of the things that counts for this round and round structure is that lawyers give one kind of explanation, but people who criticize them are looking for a different kind of explanation, and they're just talking past each other. The apparatus of moral theory helps by showing that these are both asking reasonable questions, that lawyers are answering one question, which is reasonable to ask, and people who criticize lawyers are asking another kind of question, which is reasonable to ask. And I think they're just talking past each other in many cases.
So I can certainly see that, especially with students today, that, okay, we understand you can represent Weinstein, but why would you? And when you take that next step in moral philosophy and you analyze who we're representing and why, where does it go from there? I mean, what kinds of responses can you come up with using moral philosophy that take it deeper than, well, the rules allow me to do this?
Well, it's interesting that, well, the rules allow me to do this even kind of counts as an argument in moral philosophy, because I think it's just sort of almost a default position in political theory that the law doesn't necessarily carry an obligation of respect or obedience along with it. The law is what it is. It's legal positivism. It's got a social source, and it can be traced back to process of enactment and picked out as law and not something else, Hart's insight about the rule of recognition. But that doesn't say anything at all about any reasons we may have to obey or respect the law. That's a separate argument. And so I think lawyers miss that also. They might have missed that day in their jurisprudence class where they missed Lon Fuller saying just because something is law doesn't mean it necessarily carries an obligation of obedience along with it. So there's that. But I think I don't know that you need heavy-duty moral philosophy to give an answer. I think the framework of moral philosophy helps frame the question. But the answer from someone like Ron Sullivan could be something like, and this is purely speculative. I have this list of reasons that Sullivan could have given in the book, and I've not talked to him. I have no idea whether any of these things are his reasons, but I could imagine a series of reasons such as, number one, I'm a criminal defense lawyer. I love a challenge. That's what criminal defense lawyers thrive on. Hard cases. The state's got all the resources. The cards are stacked against us. I love cases like that. And this would be a significant professional challenge. You know, one of the great cases of my career to work on this. I mean, that's a possibility, right? Possibility number two is I like underdogs. And yeah, Harvey Weinstein's a really rich guy, but everyone's already decided that he's guilty. And I'm kind of attracted to people like that. Possibility number three, one of the commentators on my book at a recent launch event at Cornell, and actually someone who blurbed it, is Abby Smith, a wonderful criminal defense lawyer and scholar. And she has said, I like guilty people. I find, guilty humanity, like fallen humanity, kind of interesting. And cases like this draw me, and maybe that's interesting to Sullivan. I don't know, right? But I think those are the sorts of things that people are looking for as an explanation. And what that's doing, to be a little fancy theory about it for a second, is bringing individual moral agency into dialogue with the professional role. So, lawyers appeal to the professional role, and they say, my role as lawyer requires me to be a zealous advocate, keep confidences, blah, 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 blah. But the philosophical question is always, yeah, but you're still a human being even while you're in that role. So how do you unify those things? How do you, harmonize that in some way? And that's what I think, oddly enough, as weird as it may be to draw lessons in moral theory from Twitter, I think what people are doing when they criticize lawyers is they're trying to say, like, I want to see your humanity in the professional role. I want to see how those two things coincide.
And in teaching professional responsibility and exploring some of these things in your other classes. Are you seeing a shift among your students over time? I mean, you've been in the academy a long time, a couple of decades, more than a couple of decades. And are the students responding differently to these questions and these professional roles and the obligations of lawyers?
Yeah, I think so. Actually, I'm working on a lecture right now that I'm going to give next week called The New Legal Ethics. And I actually do think there's been a pronounced shift in younger lawyers and law students in being very quick to attribute the wrongfulness of their client's conduct or the perceived wrongfulness of their client's conduct to lawyers. I'll often say to the class, all right, give me an example of a lawyer that you think is a bad person for the client they represent. Last couple of years, without any prompting by me, the number one example they come up with is Neil Katyal for representing these big international food companies in alien tort statute litigation. He was the advocate of the Supreme Court who prevailed 8-1, so it couldn't have been a wacky position. He got an 8-1 victory in the Supreme Court. But his clients were accused, Nestle and Cargill and other big food companies, were accused of sourcing cocoa beans in a shadowy international market in which there were middlemen who may have looked the other way while some of the farmers that grew these beans in West Africa were using child labor or even slave labor. And so the students are very quick to say, to describe Katyal's conduct as like aiding and abetting slavery. Like, whoa, wait a second. There's a lot of logical gaps here that you're jumping over. But that's where they're going nowadays. And I've not seen that before. It used to be kind of hard to motivate students to see moral agency in lawyering. They were very comfortable with the professional role. That's what lawyers do. That would be kind of the end of the inquiry. And you would have to use these hard cases to get them to think about that. There's a famous case involving a guy named Alton Logan, who was wrongfully accused of a murder and spent 24 years in prison. Turns out that the person who actually did the murder had told his own lawyers about this. And he said, I did that, not that guy Logan. But he wouldn't permit the lawyers to disclose this. But he did, however, sign an affidavit, which he allowed to be disclosed upon his death. And when he died, the lawyers disclosed it, and Alton Logan was freed from prison. And that's a really great case about the legal obligation of confidentiality bumping up against moral agency and what would a decent person do in those circumstances. I used to have to use cases like that to kind of dynamite the moral analysis out of students. Now they go right there. Boom.
Oh, yeah.
They're very quick to condemn lawyers for representing bad clients. And so I've noticed a real, I think, slipperiness in the idea of complicity, seeing lawyers as complicit in moral wrongdoing without kind of doing the work to figure out what constitutes complicity. So that's been interesting and a lot of fun in the classroom to have a very different kind of discussion.
Well, I'm sure that is becoming increasingly challenging, and I'm glad you're pushing the students to explore that. It may just be part of the kind of conclusory jumping to answers without a full legal analysis in whatever subject. You may be seeing that in torts as well, that students might be more inclined to do as they are more inundated with kind of media and lots of different sources of information. But let's talk about the 7th edition of Examples and Explanations for Professional Responsibility. So what could a professor or a student expect from this 7th edition that is different than they would have seen in the prior editions?
Well, so this is the first time that I didn't just add to it, but subtract. Like, I went back and I rewrote the whole thing. It was a lot of work. And I apologize to any of you out there who may be adopters of this book. One of the things that I have found out is that a lot of faculty have adopted it as a casebook, actually, in the class. A lot of them are adjuncts, but not all. And they just said it's accessible, it works, it's kind of fun, the students like it, so people use it as a required reading. So I apologize to y'all because I really rewrote it. I tightened it up quite a bit and then also updated it. But it was bloating. I just kept adding stuff as there would be some new topic that came up. Oh, Rule 8.4G, discrimination in a legal profession. I better address that. Well, big long thing on that. Multi-jurisdictional practice reform, that got all very complicated. Temporary practice rules, boom, stick that on there. It just bloated. And so I really kind of pared it back to make it tighter, and the publisher was happy. It was shorter. So that's one thing that's different. But I also think I've been kind of feeding in lessons that I get from adopters. I hear from people and they say, this part of the book works and this part doesn't. And so it has really been beneficial to me to talk to people who use the book and hear how it goes in class.
And I imagine your work with the MPRE drafting committee must help inform some of the revisions to this book and your rule supplement. But let me ask, we're all in the academy concerned about the next gen bar exam, and it's coming, and we're all going to have to change how we approach teaching to the bar. But I don't hear the same sorts of things about the MPRE. So is that something that the drafting committee is looking at changing? Are there any conversations happening like that?
Well, let me just say about the MPRE first, actually, that I do have sort of a firewall in my mind between the work I do on the MPRE and the E&E. I mean, these things have to be very separate. And so I'm informed in the sense that I am a law of lawyering teacher and expert and practitioner and expert witness and things like that. So all these things inform each other. I get sharper at this from working on the MPRE. And I say, actually, at the beginning of the book, I say, look, students, hey, if you're buying this for inside dope on the MPRE, you're going to be mighty disappointed. One of the things that I also do is go into a lot more depth in the book than we do on the MPRE in certain subjects like malpractice, conflicts, confidentiality, and privilege that are hard and complicated and really important in practice, but we can only do so much on a test. On the next gen point, working on the MPRE, I see what's going on with next gen, and this is just based on what's publicly available about it. I think it's really cool. To the extent people have to think differently about teaching, great, because they're going to have to be thinking about teaching to a test or in light of a test that is much better designed to measure what newly licensed lawyers have to do in practice. It's not memorized stuff. It's here's a little dossier with facts or deposition transcripts or whatever. Here's a couple cases. Now, how do you advise your client, or what claims are you going to bring, or whatever. So I think it's great. I'm a big fan, and to the extent it requires rethinking teaching, that's all to the good. The ethics part, there was an early study that the National Conference did when they were thinking about next gen. They actually had several rounds of comments. They went out to stakeholders, state courts and lawyers and educators, and they said, what are the essential subjects that lawyers need to know? And ethics always was one of the top things that lawyers need to know. But they decided to leave the MPRE alone, I think, on a judgment that it's already working pretty well in doing what it's supposed to do, which is it's not meant to be a gatekeeping exam. It's just meant to be something that ensures that lawyers are acquainted with the standards of conduct that they have to comply with, the model rules and the law of lawyering more generally. But it's not intended to weed people out. It's just kind of it's an awareness raising thing. I think there will be some ethics issues that get embedded into next gen questions. How exactly that gets developed, I don't know. Maybe us on the drafting committee will have some role, but there will be some overlap between those things.
Gotcha. Let's switch gears then for a minute and talk about torts. So you also teach torts, and you are on the book Torts, Cases and Materials, the 5th edition with Tversky and Henderson, but you're working on your 6th edition of that book. Tell us a little bit about what's coming down the pike in the 6th edition that might be different, and where the hot spots are for revising the torts case book.
Yeah, it's a good question. We did a lot of revision on the 5th edition. Aaron and I worked really hard on that and tightened it up and made it better, and I'm really proud of it. I think this will be less of a comprehensive redo, but we need to work on the defamation chapter, and I'm going to take the lead on that. I love defamation. It's fun to teach. I don't know how many torts teachers do defamation and privacy in their 1L torts class, but it's a blast, and the students love it. It's a chance to do some interesting First Amendment stuff, and been in the news a lot lately too, so it's not hard to motivate people to be interested in defamation. I think we need to do a redo on that chapter on both the constitutional stuff and the common law. It's complicated. I mean, it's really, really hard to do it well in an introductory casebook because you do have a ton of common law. It varies a lot in the states, and there's statutory stuff like anti-SLAPP laws, and then you have all the New York Times versus Sullivan and Gertz and all those cases. So it's a big subject, and I think I need to take a crack at kind of redoing that and tightening it up a little bit. At some point, I don't know how much we have to engage with mass torts and MDLs. I'm actually teaching a mass tort class right now. Love it. It's great, but another big, very complicated subject. But today, tort practice, if you read anything about a torts case, it's the Roundup MDL or the talc bankruptcy or the Camp Lejeune, whatever. These cases come up in that context. And so I don't know how much more we should say about it in an introductory course. There's a lot of procedure, a lot of pretty advanced law, like you've got to know some substantive products liability law, and there's Daubert, and it's a complicated subject, but I think we probably ought to say something about it.
Great. Well, we'll look forward to the 6th edition. And as far as your work in the law of lawyering, what do you see as the big issues that are going to require changes to the model rules and the ethical role of lawyers? on the horizon?
One thing that's kind of percolating is unauthorized practice of law, both as between lawyers and non-lawyers and among lawyers in different jurisdictions. So, multi-jurisdictional practice. On the latter, in the pandemic, there's a flurry of ethics opinions where state regulators said basically it's okay to camp out in Florida and represent New York clients if you're a New York licensed lawyer. You don't need to be Florida licensed. As long as you don't hold yourself out as licensed to practice in Florida or try to attract Florida clients. That's becoming a sort of de facto norm now, and that's part of multi-jurisdictional practice. Whether that leads to something that I actually support, which is often called a driver's license model of licensure. I'm a New York lawyer. I can drive in Florida, right? Why can't I practice law in Florida? And there's a well-known competency paradox, which is your licensure to practice in New York. I'm licensed to do anything in New York. Trust me. There are a lot of things I'm not competent to do as a New York lawyer. I'm a tort litigator. I could handle a case like that, but I couldn't negotiate a corporate acquisition or whatever, but in theory, I'm licensed to do that. That's bonkers. Yet I'm not permitted to do tort litigation in Florida. Theory is, local differences but I can do some research and figure that out. So one question is whether we're moving in the direction of a more driver's license model, and you got small states nervous about big states. New Jersey worries about New York lawyers and that kind of thing. So that's something that's on the horizon and states are talking about it. And the other is the definition of the practice of law and expanding that or contracting it actually to permit non-lawyers to provide legal services. There have been these little experiments. Washington had a paralegal certification basically, but it was so onerous that nobody did it. So other states are experimenting with this. You think about, you go to the doctor's office, you might see a nurse practitioner or a PA or a podiatrist or a chiropractor or whatever. So in medicine, we're okay with this, but in law, oh no, you got to have a fully licensed lawyer. So that's one thing that may change. Technology is part of this. How do you handle unauthorized practice of law issues where the legal services are being provided by a piece of software? LegalZoom had to deal with this in the 2010s. I teach a case about that. Now with generative AI, what happens if you have some AI-enabled thing that allows you to crank out residential lease agreements or something like that? What do we think about that? That's an issue. And then there's the interesting Arizona reform where we have non-lawyer equity ownership of law firms now and allowing sharing legal fees with non-lawyers. What's that going to do? Is that going to expand beyond Arizona? Utah has a limited thing. They call it a sandbox to kind of test out some innovations. Are other states going to start going down that road? Who knows? But these are some interesting issues that I think are on the horizon on the law side of lawyering.
Great. Well, before we conclude, I want to ask you to opine, as all my guests do, on the future of legal education in the coming decade. How do you think it is likely to change, if at all, or how should it change?
Yeah, I'm not a futurist by any means. I told you when we were prepping that when the iPad came out, I thought this is a stupid product. It's not a phone. It's not a computer. Who's going to buy it? So basically, nobody should listen to me predict the future about anything because I'm really bad at it. But to the extent you've asked me to do this, I think the legal education profession tends to be very slow to adapt, let's just say. But so does the legal profession, actually. They're both kind of small C conservative institutions, and often for good reason. That's part of the genius of the common law, actually, is to make incremental change based on the wisdom of the past and not get out ahead of our skis too much. So there's something good about that, and there's some real wisdom in the way things have always been done. On the other hand, there probably are some sensible changes that could be made. I think the third year is crying out for reform in some way to make it more experiential, to expand clinical education opportunities and things like that. I think a lot of schools are moving in that direction. The ABA is now requiring more experiential education. So I think that could continue to be expanded. As much as I love theory and classroom stuff, and that's what I do, I don't know that students need 3 solid years of that, to say nothing of the cost of 3 years of legal education. I'm glad I'm not an administrator because you're great at it, no doubt, but I wouldn't wish being a law school dean on anyone, in part because I think the pricing model is unsustainable. I just see, continued increases in tuition and the cost of attending law schools. And for us, it drives a lot of students into large firms. I'm a former big firm lawyer. I don't have a problem with big law firms, but a lot of students feel like they have no choice but to go to work for XYZ law firm and pay off their loans and then go and do what they came to law school to do. In some ways, the high cost of legal education is driving that. And if some state were really innovative and creative and licensed non-lawyers to provide legal services and they were able to do it effectively, efficiently and competently and ethically, who knows? They might run circles around the legal profession, and then legal education would have to rethink what it's doing. But so far that hasn't happened, and that's the kind of small c conservatism about this. This whole industry changes really slowly. Arizona kind of surprised me. You never know. Some state might decide we're going to be the Delaware of non-legal, who knows?
Right.
Do something cool and interesting and innovative, and then the profession's going to go, but I don't know. Like I live in upstate New York, and right up the street is Rochester, where Kodak used to go, man, we got it made. We make film, and everybody's going to always buy film for their cameras. And then digital photography came along, and Kodak is toast. That could happen to the profession, but that's been predicted for like 30 years. Richard Suskind's book, The End of Lawyers, was like 20 years ago, and here we are, doing things like we always have. And so I don't know. I keep hearing these predictions that there will be some disruptive change, and I haven't seen it yet. But again, people at Kodak in Rochester thought that too.
Well, these are interesting times for sure. But you're right. 20 years later, we're still going strong after Richard Suskind's book. Well, thanks so much for sharing some information about the 7th edition of Examples and Explanations for Professional Responsibility, and enjoyed talking about how the 6th edition of Torts Cases to Materials, both Aspen books that will be coming out soon. And then also the bonus of talking about canceling lawyers, which I think is just going to be a really interesting book for those of us in the profession, but also just a popular book that can be accessible to those even who are not part of the profession, that just came out. So congratulations on that. Enjoyed having you as a guest.
Well, thank you. I enjoyed talking with you. This has been a lot of fun.
If you'd like to listen to more thought leaders in legal education, you can find additional episodes on Aspen Leading Edge's podcast page on their website or other places where you find your favorite podcasts. Thank you.